Good afternoon, everyone. It's on the 4th, April 5th, 2023, 1:15 p.m. in the afternoon, and making this video from Florida as usual. As I said yesterday, I'd be doing follow-ups on the matters that we've been dealing with over the last couple of days, namely the ruling of the appeals court and the implications and what it means for every Jamaican, and possibly every Jamaican that owns property or a house that they bought from a developer. I don't think too many people who might be hearing this understand the magnitude of the ruling, and I'll just quickly condense that again. In effect, the court ruled that any real estate developer that did not possess a real estate dealer's license, and there are two different things, rather than as opposed to the registration as a developer. What they're saying is, if you didn't have a real estate dealer's license, which my company didn't have at the time we entered several agreements, the court ruled under Justice Ty in 2017 that it means the developer was operating illegally. We checked the records, and essentially all real estate developers that did not have a real estate dealer's license in effect were operating illegally. And what that means is every contract, every agreement entered into by a real estate developer from the time they started business until currently was an illegal contract, an illegality, as the court might say, an illegal agreement. And what that means, no court of law can enforce an illegal agreement. So anything that's drafted in your agreement, regardless of whether you started to operate or perform under that agreement, it is still illegal, and you can't, it's unenforceable. So technically what the ruling is saying, it changed the law from what it used to be, or what we perceived it to be then, and it's now saying whatever agreements we entered into, with whatever agreements any developer entered into, is an illegal agreement, and those agreements cannot be enforced. And there's a generational effect to that, meaning that any agreement that comes out of that original agreement between you and the developer, or the developer and any other party, is also illegal. So the agreement when you purchase your home or your property from the developer and is illegal. So when you took that agreement to the bank for a loan, and you produce the documents from the developer showing that you were acquiring the property from them and the bank was going to finance it, all the agreements between you, the bank, the developer, all of them are illegal and are unenforceable. Now, I've recommended, if you don't take my word for it, go to find an attorney and have them look over the judgment. And the judgment is on the website of the appeals court, on the Court of Appeal number 64 of 2018, Carif Limited, CAREIF Limited, Carif Limited, one word, Carif Limited, Carif and then Limited, versus Valrine King. And the judgment is there for you to read, and for any attorneys to read, or anybody, and you sit with people and you go through that agreement. Now, I'm not just interpreting what I'm saying to you, I'm saying what the judge explained to us when she delivered the ruling initially. That's Justice Ty. And what the appeals court said, and what the appeals court said, they agree with what Justice Ty was saying. And therefore my company and any other company that was operating without that real estate dealer's license was operating illegally. What does that mean again? It means that you should legally stop paying any loan that you got out of those contracts. You should stop paying your note that you got when you borrowed those funds from the bank. And the bank will have to work it out between the dealer, the bank, and government. Government will have to enact laws to either admit the court is right, or put it in such a way that the court can misinterpret the law again. But what in essence it's saying is the court changed the law and says the law was in effect from the time the real estate act came out, and it is in effect to date, and it will be in effect until Parliament changes it. We could have, as I said, tried to appeal it, but we're not going to, because the reality is this is a gift. This is a gift to every Jamaican that bought property from the bank or NHT, and any money that you got to pay for that property, it would be between the real estate developer and NHT, and not you. Your home would still be yours because you have possession of it, and especially people who have had possession of it for more than 12 years. After 12 years of uninterrupted possession, they can't take the property from you. So again, it's a battle for the government and the courts, and we arrived at this junction because of the corruption in the court. Now, anybody that's been following my channel on the videos that we've been releasing will realize that we've been very vocal about the illegalities and the corruption and the fraud that goes on in the court. Now, what we deem or believe happened here, which we suspected would have happened, was that they delayed our business and refused to hear our matters, and when we pressured and they had no choice but to bring forward a ruling, they came with a ruling that they figure, well, we're just going to rule against them, and what that means is they'll have to go appeal it and drag this thing out, and whatever happens. We are not going to appeal it. So in effect, the according to the law and the court, the judgment is effective immediately, effective from the very date Justice Tai made her ruling. So in 2017, when she made that ruling, it means that effectively you could have stopped paying all your loans that's on your property, on any property you purchased from a developer from 2017. And the effects of the 2017 ruling is retroactive to the time you bought your home or the existence of the real estate board and those developers operating. What that's saying is that this is an opportunity for you to use the advantage that's at hand to keep money in your pocket, and legally government can't do anything about it because the courts rule. They'll have to go and change the law or simplify the language, and I'm going to come to that, because I think one of the fundamental problems we have in this country is this attitude of the courts and government and lawmakers to write languages of laws in such a way that it's confusing, and it, rather than simple straightforward language, they put all these unnecessary jargon and even wording and words that are no longer in existence. You put Latin in a law. Nobody speaks Latin. I don't think one Jamaican speaks Latin today, and if they do, it's a dead language. It's even spoken in Europe again, and they don't go and infuse their laws in such a way that the ordinary people can't read it and understand it. Because if you can't read a law and understand it, how can you obey it or adhere to it? So it's a tricky game that they play, which is fraud. If you're trying to trick people, it's fraud, and that's what our governments have successfully done, or concurrently done when they write laws. And because why? Because we have all these attorneys who go in there to write laws or help them draft laws, and instead of writing in simple straightforward language, they write them in all these conjunctions and all kind of nonsense that the ordinary people can't understand, and they do it because they want to keep themselves employed or relevant. And that's not what the Constitution is about. The Constitution is about making things and laws that affect people's lives in a way that they can live by it or honor it and understand it. And if there are laws that are written that you can understand, then how could you adhere to it? And if you don't understand it and you're an intelligent person, why you think judges going there, you think all of them going to understand all these laws when they're convoluted and speaking all kind of strange, twisted language and tongues that it takes an interpreter to even sit down and work them out? So the fact is, if you don't want, as I said, it's to your advantage, and I'm saying to every Jamaican that's out there that owns property from these developers, too bad. Don't feel bad about it. Things happen, and it's working in your favor. It's like, for example, let me give you a classic example that drives the point home. In the past, people were arrested and sent to prison for ganja, regardless of how much they had. They became criminals. Some people are probably still in prison serving time. The courts haven't reversed those judgments. They're probably still serving time, whether here or in the US. However, over the last couple of years, a lot of jurisdictions, including states in the United States, which are independently governed, they have changed the laws, and marijuana is quite legal, both for recreational use and medical use in a lot of states. It means anybody that's caught using it now or seen using it can't be prosecuted or sent to prison or anything like that. Of course, there's the argument with the federal government that the federal government hasn't changed it, so if the feds catch you, even if it's legal in your state and the feds catch you, then you can do time for the drug or whatever it is, Mary or marijuana, whatever you want to call it. But the vast majority of people now who are caught don't do time. So when they changed the law, it became advantageous for the people who wanted to use marijuana, whether for recreational or medical purposes, without penalty of going to prison. But you have people in jail now and prison still serving time for marijuana. But when they changed the law, somebody got an advantage. And the people who are using it now certainly can't feel guilty or bad about the people who went to prison. Yeah, you might feel bad, but technically and legally, it's not on you. So it's the same thing here. When the law was written, even the real estate board was registering developers by issuing a letter, say you're registered, go build your project, you have the right to sell your project, you have the right to enter contracts and all of that. Justice Ty changed the law and is now saying, well, she's saying the law as she read it now was what it was meant to be when it was written. So maybe when I say change the law is somewhat contradictory. She's saying the way she interpreted the law and why she ruled this way is because that's what the law was saying, is that the law is saying that my company and every other developer should have had a real estate dealer's license from inception. So technically it's not that she changed the law, she's just enforcing the law. But what it means is now anybody that acquired property from developers under the law when it was written was operating in illegalities or illegal contracts with these developers, and therefore somebody has lost a lot of money, including the banks, because the developers collected the money and are off already. The banks have lost a lot of money. Now, technically, the fraud squad can prosecute these developers or all these developers that engaged in that illegal activity, and that's why the judge looked at me and said, basically, you're lucky you're not going to jail because of of the development activity and the contracts. So what the judge was saying is that technically, because of what she's now saying the law meant, was that these developers could go to prison for entering these agreements, especially after her ruling. So let's say the statute of limitations probably would have run on a lot of the contracts that were entered into, and therefore fraud, I think the fraud statute is 4 years or around there. So after 4 years they couldn't prosecute the developers, but they couldn't ask the developers to pay back the money either, because financial agreements, even with fraud, the statute ran out. So whatever money they collected from the bank could not be repaid, or they couldn't be demanded. No demands could be made for the developers to pay back those monies, or you, for the property or money that the banks lent. So the banks would legally, and I say legally in quotes, because the banks legally would have lost those funds, and legally because they can use the law to collect back those funds, because again everybody was operating under the understanding that there was no need for a real estate dealer's license by developers. So those agreements, though now misunderstood according to Justice Steyer and the appeals court, were illegal. Simply put, you need to stop paying those mortgages. You need to contact your professional organizations. And I'm doing this video specifically for the police force and the police union, teachers and their unions, civil servants and their unions, firemen and their unions, all government workers who have union representation. And if you don't have union representation, then you still don't have to pay these loans according to the ruling of Justice Steyer. Now, everybody again that purchased a home and still has outstanding monies owed and were paying loans, you're not required under the law to make illegal payments, because in fact collecting that money now would be illegal. So NHT, if NHT is trying to collect money from you from the houses, they'd be doing illegal activity by collecting money from you illegally according to the ruling. The question also arises, is whether the collections of funds from your salary is legal, because according to Justice Steyer and the appeals court, any agreements, any contracts, any kind of arrangements that a real estate developer makes has to conform to the rule of law, and the rule of law is saying they should have had a real estate dealer's license, which NHT doesn't have, and NHT is a developer. So the question arises, and this is where your attorneys might come in handy, and you have to get smart attorneys, because again some of them are scared to even put this in front of the court, even though the law is right there. The law is there and the ruling is there, so there is no argument that anybody could come in and challenge that unless Parliament go in and simply write the law in simple language, that you don't have judges going in there and in their deceptive action or fraudulent action or abusing their authority or trying to get back at people and just abusing the judicial process to harm people or take people's property, so they don't have the opportunity to do that. Because what would have been so hard to simply write the law to say real estate developers are not required to have a real estate dealer's license, and that real estate developers have the right to sell their own developments. They have their staff can sell their own developments. They don't need to engage anybody to sell their developments. That real estate developers can enter any kind of agreements to develop property, acquire property, sell, lease, whatever property. Why not use that simple written statement in law, so that there's no misinterpretation? Nobody have to be guessing what does this mean. All this convoluted language that judges can't even understand. So I'm advocating that lawmakers take a listen to the videos as well. Look at the videos, listen to what we're saying, and stop playing games with people's lives. Stop writing laws so that you have loopholes to jump through and jump through and make simple language. Put simple language into law. A real estate dealer is a person who represents a party that has property to sell, to lease, to that, as a broker. And that real estate dealer is the person that is classified as doing real estate business. And in fact, you don't even have to put that in there because it's confusing. Why not just say real estate dealers require a license to be a broker, and a broker that can sell, lease, manage other people's property. And a real estate dealer is not classified as a real estate developer. Now, as I said before, a real estate dealer or somebody who practices real estate dealing or as a broker certainly can become a real estate developer in that two capacity without there being a conflict. But what we really need is simplification of the languages in laws to avoid all of this unnecessary nonsense that comes out of the court. And I say it's being deliberately done. They do these things to keep legitimate, honest people, the ordinary persons, out of the courts, because the average person gets confused with all of this unnecessary language. And so you enter court and you need an attorney and a judge to tell you all of that. And in fact, what they do is these judges and attorneys, they interpret laws when the laws could be simplified. And I'm going to direct you to the Constitution and the Limitations of Actions Act in the Jamaica Constitution. And you'll understand exactly what I'm saying when you look at the act, because this act is so convoluted that it's unbelievable. And I'm going to just try and read some of it to show you why is it necessary to write laws like this. You have an act that says after 12 years and a person has occupied a piece of property undisturbed or uninterrupted, they haven't gotten any notices to vacate from the owner, and stated the owner, after 12 years, the owner can't come back and claim the property from that person that's in possession of the property. Why not just put it simply like that? Simple languages. And so I think it should be illegal for the country to have laws that people can understand, or the language. And the Limitations Act, and they have a short title and commencement. This act may be cited as the Limitations Act 1950 and shall come into force on the first day of January 1952. So that even before independence, the Limitations Act was in effect. And it's important that we refer to the act, because again, remember, one of the actions that we have in front of the court, and the court is playing around with this thing with Capital One and Lauren Gallagher and John Graham, where they come filing paper after paper after we've been ruled. We've got ruling in our favor that we can't be dispossessed of the property, even if we didn't have legitimate papers for the property, and we do. All right. So here again, it shows that these judges are abusing the law, abusing their jurisdiction, and abuse of the judicial process by harming people, because that's what they're doing. And again, we have it in court where the judges gave an injunction against me going on property that I've had in my possession for 16, 20 years, almost 20 years. And of course, we had rulings from the very court that says that should not happen. But these judges do it, and they throw the timeline in there to simply frustrate us and use some fraudulent means now to get people to steal property. And again, if that's happening to me, who know my rights or understand property rights laws, because they didn't know that I am a real estate broker, not a real estate broker, but a mortgage broker. So I understand the finances surrounding land, property, mortgages. They also didn't know that one of the first things I did professionally when I left this country was become a real estate salesperson, licensed and operating out of New York. So I have a good background in both areas. And unfortunately, they tried to pull stuff like that on me, and they couldn't do it because I knew the law. And I knew the laws in Jamaica. But what about people who don't understand or know the law? Why not just write laws that are simply straightforward? In fact, it would save the court so much time and energy with these nefarious and frivolous lawsuits, that when a person walks in and, for let's say for example under squatters' rights, and they walk in and show that they've been in possession of property for 12 years, then there's no need for no trial or all of that. It doesn't matter who's been paying the taxes, because the law does not require people to pay taxes to possess land for 12 years. I know the government has been pulling some stunts and fraudulently collecting money from people, and they live on the property, and they feel if they were paying taxes, or the owners themselves, or the paper owners who lost the right to the property because of the squatters' rights or the law reform, the Limitations Act, a lot of them run in and start paying up back the taxes. But the taxes can't trump or supersede the fact that possession is key. It's not who's paying the taxes, it's who possesses the property. So all you landowners who haven't been paying attention to your property for 12, 14, 15, 20 years and running back, and just pay up the taxes and figure that's it. No. Any judge that allows that, the judge is committing fraud and committing a crime, and allow you to go in and move those people out. Because the Constitution is clear under this act that it no matter who's paying the taxes. Now the country or the government can go after people to pay taxes, yes, but the question now arises, who is supposed to pay the taxes that's owed? If the person who is in possession wants to avoid complications, go pay it. That's a simple thing, avoid all kind of headaches. But the fact is that the government can't hold you accountable for somebody else's taxes. What they might say is, well, the taxes belong to the land, and it's who possess the land that has to pay the taxes. So technically, yeah, that might work. But that said, so I'm just giving an example how government undermine the right of people, or their civil rights and constitutional right and human right, by preventing them from using the courts by writing laws that are so convoluted that nobody really understands them. In this act, unless the context otherwise requires, let me see if I can, yeah. In this act, unless the context otherwise requires, action means any proceeding in a court of law other than a criminal proceeding. So action in a court of law other than a criminal proceeding. Why even mention that? Why not just say, in this act, unless otherwise requires? And why otherwise requires? Why not just state exactly what the person needs to understand? The interpretation is saying, in this act, this is what happens, and list it. Why going through this convoluted garbage? In this act, unless the context otherwise requires. Why the ambiguity? Unless the context otherwise requires. Why? For what reason would you put something like that in a law? Why not just write it? In this act, this is what's required. This is what the act says and states it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. That's how they teach you in school, to simplify stuff. The best way to effectively get knowledge across to people is keep it as simple and straightforward as possible. And then they go on to say, action means any proceeding in a court of law other than a criminal proceeding. So any proceeding in a court of law is called an action unless it's in a criminal proceeding. All of that. Land includes corporal herinterments, HEREDINTAMENTS. Who even know what that means? Land includes corporal herinterments and rent charges, and any legal or equitable estate or interest therein, including an interest in the proceeds of the sale of land held upon trust for sale, but save as aforesaid, does not include any incorporeal hereindoments. I'm pretty sure there's a way to simply say what land is. Land includes corporeal hereindoments and rent charges. So what they're saying, under the act, when they talk about land, it includes these things. Why not just say under the act, land, the term land includes 1, 2, 3, 4, 5, 6, 7, 8, and list the stuff, instead of this hereindoments, here determents, or whatever it is, and rent charge. Well, you could list it on, but I'm saying, who knows the hell what HEREDITAMENTS means? Which ordinary Jamaican knows what that means? I don't even anyway. And the whole context of it is so convoluted, because here at the end again, proceedings of the sale of land held upon trust for sale are equitable. Let me read that again. Including any interest in the proceeds of the sale of land. So it includes any interest in the proceeds of the sale of land held upon trust for sale. All it's saying is it includes any money that's being held in trust from the sale. Why not just say it like that? But save as aforesaid does not include any incorporeal or hereindoments. Hereditaments. So you see what I'm saying? Because this already sounds convoluted and contradictory and conflicting. But from you mentioned, but there's something challenging what went before. But save as aforesaid. Why? Who talks like that? Who the hell in Jamaica or any part of the world in an English speaking country talk like this? Proceeds of the sale of land held upon trust for sale. But save as aforesaid does not include any incorporeal hereditaments or determine. Parent has the same meaning as in the Deaths by Accident Compensation Act of 1952. So they're saying, oh well, the parent that we're using in here has the same meaning that is in another act that was enacted in 1952. Why even go there? Why even mention this other act about 1952? Why not just simply say in parent means XYZ and forget this nonsense about in Deaths by Accident Compensation Act of 1952? Why even go there? A different act. A different act. Why are you going to put parent has the same meaning as in the Deaths by Accident Compensation Act 1952 as for the time being extended by any other enactment, personal estate, personal property do not include chattel real estate. You know what this act is about? This act is simply saying that if you don't take action by a certain time on certain measures, then you've lost the ability or opportunity to take those actions. Why all of this nonsense? Why all of this? Now, which ordinary person in Jamaica? Because I'm having difficulty even, you have to read it 50, 60 times to understand it and look up words that's not even in the lexicon of the language. Again, people don't even use words like that. Alright? Then rent includes any rent charge and a rent service recharge means any annuity or periodic sums of money charged upon or payable out of land, except a rent service or interest on a mortgage or land. You see this except nonsense again, like the but, and except a rent service or interest on a mortgage on land. Why even go there? Why not just define what mortgage is and say mortgage does not fall part of what is considered rent? Just say mortgage isn't considered rent. I'm not going to waste a whole bunch more time with it. I'm just showing you how convoluted these people make things for people to understand, and it's being done for a reason. It's being done that ordinary people don't understand how to get into court and manage their business, and you have the human and constitutional right to understand the laws of the land. So if you have attorneys that are retained by lawmakers to write laws, and they're writing all of this nonsense, and this is just one of the laws that should be very simple and straightforward. So what about other laws? Why all of this but and from mentioning other acts and compensation and dead people and all of that, accident from death and death from accident? Why mention that in a law that's simply trying to say to people, if you are in possession of land for 12 years and the owner didn't come to you for it or didn't give you notice that you're renting or to vacate the property, then the owner can't come back and claim the property, and that's the constitutional law. Why not simply say that? Because you see, when you do this, you have some knucklehead dumb attorneys and judges come in and try to trick people because they themselves don't understand the law. Because I'm saying this, because I was in court, the appeals court, and we came in front of this judge. First of all, the judge never even know the difference between a money instrument and a security instrument. And when this came up, somebody that we were acquiring a project from, had acquired a project from, and he had been in possession of it for several years. He had a mortgage on it, didn't pay the mortgage, and the mortgage company didn't come in and collect any money from him after the statutory period of 6 years. And in fact, the mortgage company or the bank discharged the loan. And when a loan is discharged, it means the bank write it off. Then can go out and try to collect it already again. Because if they do, when they write off that debt, they already made claims against the tax administration for losses and those taxes. So if they're claiming it and writing it off as tax loss when they don't have a right to do it, that's fraud. And those banks are doing it. So I came up in front of this judge, and I said to the judge, well, the gentleman can't be dispossessed of the property because the financial agreement he had with the bank, the statute of limitation had told, it's way over 6 years. It's now 15 years. And the judge went and said, you mean if there's a mortgage on the land, you're saying if there's a mortgage on the land for 30 years, the statute of limitation wouldn't apply to him? Yes, that's what the law says. Dummy. The law says after 6 years, no financial agreement can be enforced against the party if the party that owns that or has a right to that note has not made any collections from that person over that 6-year period, and that person has not responded to anything this person has done, and they didn't take any legal action to repossess or possess the property that's standing as equity or security, then they don't have no right to take the property from that person. But the judge was laughing and turned to our colleagues. Now I'm talking about the appeals court. I said, oh, so you, even a mortgage 30 years, you think, I mean, it's stated in, I won't go through it and read it, but it's stated in the act. After 6 years, you can't go collect no money from somebody if you never take action to collect the money in the first place. So again, it's just showing you that either this judge was trying to mock me or fool up the person who owned the property. Say he really not have no right now because the mortgage is 30 years. And so if for 30 years the statute of limitation doesn't apply, the Limitations Act, which is garbage. That's not the law. But they pull that stunt on people because they want to screw around with people's lives. And I'm saying we can keep things simple and straightforward and make life easy for everybody. But one of the fundamental things that we need in this country, and it's not changing the constitution. It's simply to write the languages of law that's enacted by Parliament in simple, straightforward languages. And we speak English as our formal language. Don't even go write it in patois. Write it in English. So it's simple, it's straightforward, and there are no complex sentences that stretch out with else, but, or, not necessary. You're only complicating the lives of the people of this country. And the only reason people try to complicate things is when you're trying to con them out of the money. Scammers do that kind of thing. And lawmakers should not be scammers. And people in government that people elect to represent them should not be scammers. They're going there to represent people, and represent people in such a way that they understand what their rights are. And if they're going to court by themselves, the language of the law should be so simple and straightforward that they can go in there by themselves and address matters and understand it. So going back to the video yesterday where this judge was now saying, oh, she made a ruling to because Mrs. King was confused about a joint venture agreement, so that people don't go into court and judges can look at them and say they're mentally handicapped, that them mental faculty has declined, them can't understand what's going on, because the way the laws are written and the way judges write the laws or the rules in the court, or the administrations in the court and the attorneys, all of them trump up to screw with people's intellect, so that ordinary people who are citizens of a country can't go in a court and represent themselves in simple stuff like land possession, land ownership, your rights. And again, it would prevent a lot of this backing up of matters in court. Because if a person challenges somebody who is in possession of property for 12 years, or they had loans from a bank for 15 years and the bank didn't collect no money from them, they didn't make any payments, and they didn't go out and restart the statute of limitation by saying, oh yes, I owe you the money. Oh, that's a game they play too. Remember, they write the law to trick people. So if you make a payment during that period, or the bank trick you and you made a payment, or you come in and sign paper and say, oh, I owe this money, then they restart the clock on it. So again, learn the laws, learn your rights. And it's nothing illegal or bad. These are advantageous things that put in law that benefit rich people. That's how a whole bunch of land barons throughout Jamaica own so much land. You think a lot of them land barons in Jamaica, especially them long-term English people who came down from colonial times and their family, you think a lot of the land they got it legitimately under the law, under squatters' rights. But what I'm saying, they know the law, so they took advantage of it. And squatters' rights, there's nothing illegal about it, and I'm not knocking it, because it was written for a specific purpose. It was written that if property is sitting idle in a country, and there are other people who can use that property to be productive and therefore build the country's economy, and they've gone in and taken the property and worked on the property, and they've had it for over 12 years and nobody has disturbed them, then by right they should have the right to that property, because the other people never want it. And that's why they say even government land people can do that. But what they did with the government land, they put 60 years. And again, government land is people's lands, So what they're saying, before you can take the lands that belong to the citizens of the country under squatters' rights, that's governed by the government or the state or the crown, then you have to have it in possession for 60 years. So the law is not a bad law. It is there so we can sustain civil society, so that when you drive down the block in your neighborhood, somebody not abandon them houses and they stay there rotten down for 15, 20, 30, 40, 50 years, and is a nuisance property harboring insects, rats and villains and criminals. Somebody can go and see that property sitting and say, you know what, let me go and fix it and they take a chance, because if the person comes before the 12 years is up and they give them notice, then they have to come out of there. But they take a chance and say, all right, let me go and fix it up, stay there. If the people come, maybe we can arrange to buy it from them. Our worst case scenario, during this 6 or 7 or 10 year period that I may have it, let me take the time to save myself some money, that I can go buy other property in the meantime and build up. So if they do come before the statute run, at least I have someplace else to go. So it's not a bad law, and you can use it to your advantage. And the person who owns the property, they have to be vigilant. You have property in Jamaica and you move abroad for 30 years, and some of you don't even pay the taxes. You move abroad for 30 years, and then you pop up because you hear that things are bubbling in Jamaica or anywhere else, and you come now and run people off of the land that's been there for 30 years. That can't be right. And it's not only in Jamaica. Every country that came out of the British experience and even European experience, they have a constitution, they have squatters' rights. So in the US, I think it's 7 years. So if I'm in the US and I see property sitting for over there idle and nobody is dealing with it, and I go over there, clean it up, plant something on it, maintain the property, and in the US you have to pay the taxes. But you can wait until the 7 years to take a chance and pay the taxes, or you pay it before, because in some states, if you don't pay the taxes for 3 years, the state can come in and sell what is called a tax certificate and to somebody, and they can come in and take the land, whether you have it for 7 years or not. So or they come in before that 7 years is up. In short, I'm just saying there's nothing wrong with that. There's nothing wrong with seeing advantages in laws and things that occur as a result of those laws being put in effect. So when Mrs. Justice Tai, made her ruling, what she was in fact doing, was saying to every person that entered agreements with developers, including NHT, that those agreements were illegal, and therefore you are not under any obligation to honor the agreement. Remember, she told Mrs. King, so Mrs. King does not have to honor the agreement we have. So the same thing applies to you. So the court, and remember the appeals court upheld it. It's saying you are under no obligation to honor this agreement, and the court cannot order anybody to honor the agreement, or the court cannot tell us we can enforce the agreement. So in short, the advantage that you have gained because of that ruling, take advantage of it and put some money in your pocket. Take your property now and claim it, and write to your bank and say, we are going to stop paying this note because it is an illegal agreement, an illegal arrangement, and you must take it up with the courts, take it up with the law, take it up with government. But for now, I don't owe you a dime. I can't be forced to pay the loan. And put that money in your pocket. Government jerk you around all the time, and you're supposed to get your salary because they say laws and that allow them to do it. They jerk you around when you're supposed to get your health benefits because they say laws and so allow them to do it. They jerk you around when you're supposed to get your health benefits because they say laws and law allow them to do it, and the minister can do XYZ. Well, this is saying they can't force you to pay that note. They can't kick you out of your house. It's your property, because they cannot come and take it, because every action they engage in contracts was illegal. The guy who built it can't come back and claim it because he collect money from the bank illegally. So technically he committed fraud, and therefore he can come back to you and say, oh well, the law cheat, the judge ruled this way, and therefore if the agreement was illegal, then the property is mine. No, he got paid illegally or not, but he got money for your property. And so make the courts, make the banks take it up with the judge, take it up with the lawmakers, take it up with the developer. But for you, the homeowner that bought this property, take advantage of it. That's how people build up themselves. As I say, these colonialist land barons that are here, some of them still here, they own millions of acres of land. Why? Because they use the law. I remember the Dillisers who were here. The Dillisers had so much land under their control in Montego Bay especially. It was unbelievable how much land these people had. Kajar, the same thing, how much land they have. And all of it wasn't by no grant by no queen. And in fact, the queen needed to check her out too, because them only come in and capture Arawak land or Taino land, native land. And I have native blood running through my body too, so they take away land before. So I can lay claim, say I am original people. I am original people, and the land belongs to my people. Regardless of how small that genetic marker is, it's still here. Alright, so, and I'm not just saying it out of general terms like how some people say, oh, all of we were king and queen of Africa before they grab up. That's not true. Now I have the scientific proof, evidence to know that I am Taino or Arawak, wherever they used to be native, and I am Maroon by virtue of my ancestry, which we can walk that back. I'm 6% Peruvian, and I figure the same Peruvian ancestry is throughout the region. So I have a legitimate claim to being this in the Caribbean. Columbus now have nothing over me. That said, please take time to review the information you're getting. It could be critical to your financial success and your future. When you have advantages in law or in life, take it. I'm going to give you a short gist of a big mistake I made when I went into New York, because I was afraid to act even though I had the legitimate and legal right to do so. When I lived in New York, I had some clients and they owned some property in Jamaica, Queens, in a nice neighborhood, nice house. And when the person died and I was acquainted with them, I noticed the house nobody was there. The daughters had left. They were living in Brooklyn. They used to only come over to visit and stuff, and they were used to go to Brooklyn and they stayed up, and they just abandoned the property. And I watched that property for months and months until people start going over there and strip it. In fact, before they start stripping it, I met with the daughter once and we ran in and we were talking, and we said, what are you doing with the house and blah blah blah, and she was like, we don't have no interest in it. You want it, go take it. And I was so stupid, and I said stupid because I was stupid. Not only did I get permission from the owner's direct descendant, daughter and family who used to take care of him, but take the house. She didn't have no interest in it, coming back. And I was so hesitant and kept questioning, should I go? If I go over there, people go see me over there, they go think me just to capture the place. Capturing the place was legal, you dumbass. It was legal. The Sikhs, a whole bunch of Sikhs from India come over and they capture so much commercial buildings in St. Albans and Jamaica, Queens. It was unbelievable. And I'm running up and down, come from a country where squatters' rights is well established. I have a real estate license. I'm afraid to go check the property because the people I was hesitant to say what people are going to say and think. And no, I should have just go over there and assert myself. First of all, the property stayed there until people go in and start strip the siding off of it, strip out the thing off, strip out the copper, and eventually happen. The city come in and condemn the building and board you up and take it. So don't be as dumb as I was. I keep saying, I'm on my way out. A lot of you are listening are young people, still in your prime. Still, and even if you're 65, 70, 80, you might have 2 more or 20 years or 40 more years, depending on medical advancement, to live. And if the Father wants, he can make you live as long as you want. And This is something I should plug. Make sure you understand that there is in fact a God, and Him will look out for you if you do the right thing. Because He has looked out for me. A whole bunch of stuff that happened. Sometimes you don't know why it's happening, but at the end of the day, you see, oh, this is it. God is a genius, not me. And you don't understand what's happening until you find. But when you see advantages in life, sometimes these opportunities are there for you to seize, to take advantage of. Just study it. Again, study your environment, understand it. So what I should have done was not just think, oh, when Jamaica you capture land, it's okay. And no say, there's no difference in America. And in fact, in America, it's 7 years or even less. And instead of doing that kind of stuff and building a good portfolio, then I fooled around and lost a piece of property. And that property was worth probably about 100 and something thousand US dollars at that time. So not only could I have the property and have rent it out and make the rental money, but the equity and appreciation would have been there after 7 years. And in Jamaica, in the US, it's so much simpler. After 7 years, you just go down and fill the papers, make sure you pay up all the taxes, and boom, it's yours. And that's why I said, when they're playing games in Jamaica with this convoluted language, and you have to go through this, and you have to file how many papers with the real estate board, and you have to go through this, and you have to go through that. Why not just make it a simple transaction? You go down to the tax department or land department, you prove that you're on the property for 12 years, you produce the evidence, whether affidavit or witness statements, and you go down and you hand it to the real estate board, not the real estate board, the titles office, and you pay them the fees to register it, and boom, you're in your property. Why you have to go through all of this nonsense? Why are you putting people all of this in a first world country? In a first world country, so many things are just as simple as you want to make it. I want to transfer the ownership of property that I have to somebody else. You do a quit claim deed. All you do in a quit claim deed, they have standard forms that are written up. You just go in and fill it out. That's the other thing. The titles office is one of the best structured and operational bodies I see in Jamaica. I have to say that because I've dealt with them. They're pretty professional. But they can make the forms simpler. Why not produce a simple one-pager and have people just fill in the information, you go down, you pay the necessary fees, and boom, they transfer the documents. Why they have to put the persons applying for this, that, through all these quantities of paperwork and some ambiguous questions and form this and form that when it's not necessary? Why are we complicating things? Because it complicates things not only for the people but for everybody, including them. Just have the person fill the necessary information, you review it, stamp it, and they're out. But everybody is structured so attorneys at Jamaica can rip off people. Because every time you go down to those companies, they'll say, oh, you need to get an attorney. I went in there once and said, you're recommending attorneys? Because if you recommend an attorney and he screw up, you're liable, right? And that's what these people don't understand, because people don't want to sue them. But when they force you to get an attorney screw up your business, they're liable because they recommend the attorney. That's why in the US, you have to make a disclaimer. If you're talking about taxes, you can say, this is not tax advice. I'm not giving you tax advice. Because if you say nothing that giving tax advice or legal advice and somebody go in court and mess up because of your advice, you can go to jail. They can sue you. So in short, when you're going to government offices here and state organizations, even when the documents are there and simple, they send you to say, oh, you can read this and read that, but we can't give you advice. I can't tell you to sign on the document here. I can't tell you to have your wife sign on so she could be on the document. No, you have to go out and get that kind of advice someplace else, because they then become liable for a lawsuit. Same thing here. Why are government agencies and agents telling people they must get an attorney to transfer land and this and that? Why not just make the process simple and straightforward? Because again, you have all these attorneys who have their self-interest And all they want to do is write laws for lawmakers and put things in place so attorneys keep working. And government isn't there to employ nobody like attorneys. Government is there to manage the people's business and ensure that people don't end up being taxed, overburdened, and cost them money that they don't need to spend. I want to thank you. Again, share the information. Please subscribe because it makes a difference in getting the information out to people. My objective is trying to make you as conscious as possible of what's out there, how you can navigate, how you can take advantage of situations for your own empowerment and your family's empowerment. So again, anybody that's a civil servant, a teacher, a policeman, you work, you're paying housing trust, you're paying all of that, go look at the videos on this channel that I've put out there. Do the research. I mentioned a whole bunch of stuff. Go do the research there online. Read it up and stuff for yourself. See how unnecessary things are done to you. You should be offended because it's an insult that government is out there producing and making your life so difficult, including producing documentation and paperwork to scam you, and scam you on behalf of attorneys and judges who support attorneys who are themselves committing fraud. So thank you. Have a great day. We'll be talking again hopefully soon. And get the message out. Get this information out. Call somebody you know that's a civil servant. Tell them to go there and listen to this. And then stop spend money you don't need to spend. Keep that money you'll be paying these people in your pocket. Make the judge or judges who may put this into effect and the government and them other people work it out. Oh, and by the way, somebody told me that the Prime Minister's wife or the Prime Minister himself are involved in real estate development. You know what I'm going to say now? Are they in possession of a real estate dealer's license under the company that they are using to develop these properties? Can you find out for me, please? Find out the name of the company. Call them and ask them, you have a real estate dealer's license? And if they don't, post it. Put it in the comment section so we can go ask the Prime Minister, how you operating illegally? When the judge say you're operating illegally. Thank you. Have a good one. And I look forward to sharing more information with you. Bye.